Court, all rise, please. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give me attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the May 8th, 2023 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Marguerite Grant. To my left, Justice Rachel Hirschfang, and I'm Justice Eric Nyman. We will be your panel this morning. Usual appeals court rules are in effect. Each side has 15 minutes to argue. There is no rebuttal in the appeals court. On occasion, you will see the judges looking down at our computer screens. I assure you we are not reading the newspaper. We are not looking at the funnies. We are simply checking the record and the cases in real time. So with that in mind, we will call the first case on our list, docket 22P 835, and please correct me on this pronunciation, but I believe it's Kinyunye versus Clinton Millworks and Minall, and we will hear first from counsel for the appellant.
Good morning, Your Honors, and may it please the Court. My name is Michael Forrest, and I represent the appellants in this matter. Your Honors, the question before the Court today is whether an out-of-state utility submetering company injures Massachusetts residents when it unlawfully submeters utility service at the residential building. The default position in Massachusetts is that a residential landlord is to provide, the regulations define provide as to supply and pay for, utility service at residential units. The start position of submetering in some instances is permissible. For example, under 186 Section 22 of the Mass General Laws, a residential landlord may submeter for water and sewer service if it complies with all of the requirements set forth in both the statute and the corresponding regulation.
Counsel, let me interrupt you. There are a number of issues and sub-issues in this case, and I think getting some structure is important for this argument. My understanding of your argument is this, and I'm quoting in part from your brief. Your central argument is that Minall overcharged tenants by charging them an amount greater than what they would have been obligated to pay if they had been provided their utility service by the authorized utility provider. And you're saying that there is evidence in the summary judgment record that you have met that standard. My understanding is that's your first argument. And I'll call it your alternative argument, is that even if you haven't done so, that you are still entitled to nominal damages under Chapter 93A due to the violation of a legally protected interest. Am I correctly framing your two central issues?
Yes, Your Honor, generally. The only exception I would make is that with respect to the submetering itself, while water may be permissible, gas submetering, and I apologize if you had mentioned this, gas submetering pursuant to the DPU and DPH is strictly prohibited in the Commonwealth.
Right, and that goes to your alternative argument that even if you don't prove specific particularized harm, and we'll get into that, you're still entitled nonetheless because of that violation to nominal damages at a minimum.
Your Honor, we would still contend that a separate injury must exist in order for damages under the Tyler standard. But with respect to the submetering generally, both water and sewer in this case were included with base fees or base charges. And one of the plaintiff's appellant's arguments here is that Section 22J of 186 Section 22 says that no administrative, base, or other fee may be added to a utility bill. So with respect to gas submetering and water submetering, the bills provided in summary judgment do include this base charge. So one of the arguments on summary judgment, which was not addressed by the court, is whether or not this base charge, which doesn't amount to $25, constitutes a separate injury for the purposes of the Tyler standard in 93A.
Now, as to the evidence that I spoke of earlier, the evidence in the summary judgment record that you point to that shows evidence of damages is at Record Appendix 1, pages 148 to 177. Is that correct?
I believe so, yes. Those should be the copies of the bills.
Those are the copies of the bills.
Correct.
Can you tell me with great particularity, tell us, how that constitutes evidence of harm here?
Of course, Your Honor.
And when I say evidence of harm, I mean under the standard articulated, sort of the Hirschenau, my clients paid more than they otherwise would have paid had the proper utility been charging us.
Yes, Your Honor. So with respect to the base fee on the bills, I do believe that because Section 22J specifically enumerates that no administrative or other fee shall be charged to a utility customer, this is not a charge that the actual utility itself would have charged to the customers. Further, with respect to the water submetering, one of the issues is that the defendant in discovery acknowledged that it does not monitor the common areas separately. So the idea here is that at a trial, the plaintiff can show that there was a mixed rate that was applied, and that mixed rate alone violates that interest in their right to have the landlord provide, supply, and pay for utility service.
But how did the bills show that that was more than you otherwise would have paid? So in other words, assume for the sake of argument that the bill you paid for gas that your client paid, including fees and including any common area usage, was $40, mine all charged $40 per month. How do we know that, let's say, NSTAR or National or whatever service provider would have charged that same month a lower amount? How can we infer that from those bills?
So, Your Honor, I think that the question is whether or not the underlying practice, the first question is whether the underlying practice itself was lawful or unlawful. And I think what
I understand, I understand that part of the argument, but I'm trying to get again to that Hirschenau standard of that we were worse off. So again, take my hypothetical. Your bill, client's bill for the month of June was $40 for gas usage, and that includes everything, the fees and everything from mine all. How do we know that the national grid bill wouldn't have been $45 for that same month?
Your Honor, I don't believe that that's the standard. The appellant does not believe that's the standard to establish damages.
Okay, but just for purposes of my question, you would agree, based on this record, we can't answer that question?
Correct, Your Honor. I do not believe that based on this record. I do believe based on this record we see the unlawful administrative charges. And relying on Hirschenau, the Hirschenau court clarified the Liardi holding. And in Hirschenau, the court explained that in Liardi there was a separate and distinct injury. And in Liardi, the injury itself was the interference with a tenant's legal rights. Here, the regulations and the statute provide that if a tenant has a problem with the rates being charged, they have an automatic right to a hearing. Here, when you have a private company, in essence, reselling electric and water to that individual, they lose that right. And under the Liardi and the Hirschenau standard, that constitutes a separate and independent injury for the purposes of 93A.
So in your view, then, in any case in which a landlord unlawfully separately charges a tenant for, say, gas, any utility, there has been a legal injury, even if the landlord is provably charging the tenant less on a monthly basis than would have been charged by the applicable gas provider?
I do believe so, Your Honor, and I believe so because of the fact that there are strict requirements put in place by the DPU and the DPH for this regulating of services. One of the things the trial court pointed out was that the measure of damages here, the trial court believed, was the difference between the two types of rent. However, this court has held that a landlord is not allowed to reduce rent in order to avoid its legal liabilities. In essence, the trial court was saying that you need to show that these two prices would not have been equivalent for rent. But in essence, in saying that, it's asking us to take a discount for the unlawful activity of the first landlord in that instance.
But I just want to follow up on the question I asked. So I want to understand how, in your mind, because I know you've thought about this, that position squares with the requirement in Tyler versus Michael Stores that some injury, that the plaintiff shows some injury beyond merely having her, I shouldn't say merely, beyond having her personally identifiable information stored and taken by the store.
Your Honor, with respect to damages, I believe there are several independent and separate injuries here. The first injury is that the regulation and the statute specifically say that a residential landlord must provide utility service. And again, it's important to recognize that the definition of provide means to supply and pay for. So by illegally submetering utilities, in essence, a residential landlord is foisting its financial responsibility on the residential tenant. So the appellant takes the position that that's your first injury here. It's the foisting of charges. The second injury is that the defendant has acknowledged that there is a common area submetering, which may create a blended rate. Again, pursuant to the regulation and pursuant to the statute, a residential tenant cannot pay or should not pay for common areas. So if common areas are included in what is the split billing for the building, then that again would be an injury for the purposes of 93A.
When you say foisting of charges, by the way, you're talking about those fees which are not allowed to be, correct?
No, Your Honor. I'm talking about with respect to the water submetering. In discovery, it was uncovered that they do not separately and properly monitor common areas.
Got it. Okay, thank you.
The third distinct injury is that base charge, which is added to the bill. And Section 22J is explicit that no administrative or other charge shall be added to a bill. Here, in black and white, we have a base charge that's added to every bill. While it may not amount to an amount over $25, the appellant contends that that at least satisfies the independent injury requirement for nominal damages under 93A.
Can you go back to my earlier hypothetical in line of questioning? And I understand your position that that is not required to show injury. But could you have hired an expert, say someone who worked for National Grid, assuming National Grid is the underlying supplier here, for hypothetically, and had them measure your client's usage in an apartment of that size, absent any common area usage, absent any fees, and the expert could calculate what the monthly cost would have been of providing that service from the utility?
Yes, Your Honor. I do believe that an expert could have been employed for that purpose. But I think that the appellant...
Go ahead.
Sorry.
No,
I
you
think
go
that
ahead,
the appellant sees it that there are several injuries that occur before needing to do that, and we don't need to unring the bell of all these other injuries which have occurred, which the appellant contends constitute violations of 93A independently. And I acknowledge that this is an agent of the principal residential landlord, but again, this court has held that an agent can be independently liable for unfair and deceptive acts. Your Honors, with respect to the damages, we've discussed the price regulation. Oh, I'm sorry. The other damage is price regulation. The residential tenant has a right to price regulation. The DPU is very specific with how they regulate utilities in the Commonwealth. Under a submetering scheme, there is not a regulated utility price because the submeter in actuality resells the utility to the residential tenant. So with respect to damages, I do believe that with these 3 or 4 individual injuries, separate and distinct injuries, the requirements for pursuing a claim under 93A were met at the trial court level.
Now, 3 different judges in this case either adopted or at least repeated a certain standard for a measurement of damages. In the second summary judgment decision, the one that's fundamentally under appeal here, the third judge said, quote, the measure of damages was the amount plaintiffs paid for rent and additional charges that exceeded the fair rental value of their unit, end quote. Your brother says that you don't appeal or did not appeal any of the judge's determinations of what the proper measure of damages is. What's your response to that?
Your Honor, I would disagree with my brother. I would say that presenting individual reasons or individual damages to the court through the appellant brief satisfies that requirement. The other thing I would mention is that the trial court does rely on part of Judge Fabricant's decision in Friedman. It kind of takes part and then leaves the other to decide. In Friedman, Judge Fabricant did articulate a very similar set of damages. However, she said that because of legal interest, and I paraphrase, because of a legal interest being violated here, there's at least nominal damages for unlawful submetering. So we do have a case in the Superior Court where we've also had a judge say, if you illegally submeter, there is a nominal damage here because you've interfered with a tenant's rightful or legal rights.
And you believe that aspect of Freeman survives the Tyler versus Michaels Stores decision?
I do, Your Honor, because I believe in Hirschenau, the court goes on to explain. I know there's been a lot of confusion as to whether or not Liardi was overturned or was it not overturned. Appellants take the position it was not overturned, but it was clarified by Tyler and Hirschenau. And again, in Hirschenau, the court said that the invasion of a legally protected interest, for example, here a right to an automatic hearing if you challenge the regulation or the regulatory fee, has been taken from them. So I do believe that there is an interference under Tyler and Hirschenau which constitutes a separate injury for the purposes of 93A.
But the post-Liardi cases have clarified that that hasn't eliminated your burden to prove or demonstrate at the summary judgment stage loss causation. So I guess the question for us is whether or not those four things you cited, the foisting of charges, the common areas, the base charges, and the price regulation constitute loss causation.
I believe, Your Honor, if you say causation in the financial sense, I would just say that under 93 it doesn't need to be
economic or non-economic.
a
Yes, of
financial
course.
injury. However, I do believe so. I do believe that those four injuries themselves meet the Tyler test. Take any one of those. The base charge itself, which in some instances may have been as small as 13 cents or 54 cents, that's more than a penny, and under Aspinall, that would constitute nominal damages for 93A.
So otherwise said, part of your argument is that everything the appellee points to is simply economic harm, if we accept their arguments, but they haven't considered the non-economic injury.
Correct.
I shouldn't say they haven't considered it, but they haven't demonstrated.
I think we disagree on what the economic injury is. I think that I do see an economic injury through base charges, for example, but I do understand that we disagree on the economics of things.
The appellees rely on Judge Young's opinion in Conley, and I noticed that your briefs don't cite to that. Can you distinguish that case, or is there a reason you don't cite to it?
The reason I don't cite to, Your Honor, is it's a federal district court case. It was actually my case. I don't believe that I didn't agree with Judge Young's position. It was actually sent up to the First Circuit. That case did resolve outside of the First Circuit, and it's the same argument. Judge Young does believe that the benefit, and I apologize, Your Honor, my time has expired. Would you
Please
like me to
finish your
that the benefit there conveyed is similar to Judge Reardon's decision, that you need to look at some sort of economic formula, whereas the plaintiffs in that case, just like here, put forth the fact that there was no base charge in that case, but put forth that there were some other issues of legal rights being interfered with.
So your argument is that we're not bound by that because it's a federal trial court decision, but we should consider ourselves bound by whatever part of Freeman survives Hirschenau.
Your Honor, I only bring up Friedman because the trial court, and it's been raised throughout this, it's directly on point. It had to do with the gas submetering. Obviously in Friedman there was a potential for variance. Here it's prohibited, but that is the reason that we rely on it, because it is really one of the only cases in Massachusetts that's dealt with this issue.
Seeing no further questions, thank you for your very helpful
Thank you very
argument.
much, Your Honors.
We will now hear from counsel for the appellee.
May it please the Court, Neil Hartzell on behalf of Mine-All, Inc. We are asking this Court to affirm the summary judgment decision in Mine-All's favor from the trial court. The issue on this appeal is whether the March 20th, 22 summary judgment decision that dismissed the plaintiff's Chapter 93A and declaratory judgment claim should be affirmed where the plaintiff never put forth any evidence of damages. I'm not going to go into the prior procedural history. Suffice it to say, I'll just touch on it briefly. There were some counts that were earlier dismissed. There was our first summary judgment decision where that Superior Court judge said if it turned out that Mine-All somehow financially benefited from submetering, that's an avenue for discovery. And the tracking order in this case was extended twice. And then the first Superior Court judge's decision also said you can have more discovery to try and develop your damages. Well, aside from identifying an expert at one point in time in their supplemental interrogatory answers, there was no opinion from any expert that anything that Mine-All did enhanced their fees or they somehow improperly benefited from it.
Well, let's talk about that. So take a look at Volume 2 of the Record Appendix, page 149. That's one of the Mine-All bills.
I have it right here.
So in the top left, it says Water and Sewer Service. This is for a month in 2018. It says at the top, this is not from the town of Clinton. And then below that, there's Gas Service for the same month. And it says, this statement is not from National Grid. So are we to understand then that the water utility is being provided by the town of Clinton and the gas utility at this address is being provided by National Grid? Is that?
That is correct.
Okay. Now, presumably, National Grid would not have these base charges.
I have an answer to that, Your Honor.
That would be great.
The affidavit of Mr. Griffin, Volume 2 of the Record Appendix, at page 220, paragraphs 10, 11, and 12. He explains what the base charge is. The base charge from National Grid is part of the minimum fee charged by National Grid. In other words, National Grid charges a minimum fee every month, and that minimum fee was divided up by Minol and added to these bills. As to water and sewer, there's minimum charges where the town doesn't come out to read the meter. And those minimum charges are factored into the base rate. And Mr. Griffin explains this in his affidavit. So he says these charges are not an administrative fee and there's no service fees charged. So
When you say minimum charges, because I scrutinize my water and gas bills with probably about the attention of the average consumer, I don't recall ever seeing a separate charge broken out, but it may be that I just missed it. Are you talking about a minimum charge that is not subsumed by the actual charges for the whatever it is, the gas or the water used?
I don't purport to be an expert in the intricacies of utility building at this particular complex by these particular utilities. All I can tell you is that the affidavit that's in the record explains that these, because it's a minimum charge for the National Grid and the months for water and sewer where they don't come to read the meters, there are these minimum charges that they send.
Is the affidavit
These-
referenced? I'm sorry.
Go ahead. These are charges for months where they did read the meter. I mean, the
Well-
pages that we were just looking at together had usage measured in, hundredths of a cent per unit.
That is correct. As I understand it, Your Honor, again, I'm no expert in this, there is a charge that comes every month, or it's factored into some months where they don't read the meter, and that gets spread out over the life of the yearly utilities. But the point of all this is that they continually claim that these base charges are improper, that these base charges violate the statute. But the explanation in the record is these are not improper charges.
Where
and
that
not
begs my
administrative.
question. We're at summary judgment here. So is the affidavit that you're referencing, is that referenced in the statement of undisputed material fact?
I haven't gone back and reread that, Your Honor. I don't recall.
That's how summary judgment, our review's de novo. So we
I
have to look at
understand,
this.
Your Honor.
So
I
don't mean to
did
interrupt
argue-
you, but let me just finish.
Sorry, I didn't mean to.
Our determination is based on what is in the statement of undisputed fact. So number one, that affidavit would have to be referenced in there, or at least cited to, number one. And then number two, it would have to be not disputed by the other party. So barring those two things, I don't see that that does anything other than create an issue of disputed fact. It may be a helpful explanation for this court.
Well, there is no dispute about it, Your Honor. They are saying.
If it's not referenced in the statement of undisputed fact, it doesn't exist for purposes of the summary judgment record. So first, it has to be referenced or cited to therein, and we will look to double check to make sure it is. And number two, then the question is whether or not it is disputed by the other party and whether or not they can point to some evidence showing that it's incorrect.
I argued the summary judgment motion, Your Honor. I would have to go back and double check the statement of facts. I know that what was in these affidavits was raised at the summary judgment hearings. I remember doing it. One of the issues was, what are the damages that you're showing? How can you show that these are improper? And despite having a couple years to do this, and despite having apparently identified an expert at some point in time, they never came up with any damage record. And I want to correct something else that counsel said. Base charges. They admitted they didn't separately meter base charges. Base charges aren't part of the equation. We didn't submeter the common area charges. If you read Mr. Griffin's affidavit, it says they were not charged for common areas. Because, why is that? These submetering devices, you have the line from the utility company that comes into the apartment building. And then from that main line, separate lines go to each apartment. So what these submetering devices do is they attach to those lines that go into each apartment. They're not looking at the main line. They're looking at the lines that go into each apartment, and that's how they submeter the actual use. So the affidavit says they weren't charged for common area maintenance. So that argument that we were charging for common area charges and somehow that skews all the bills is completely wrong.
The argument you're making is strictly referring to damages, correct? Not the legality of your client's action.
Economic damages.
It goes to the damages. That is correct. But it also goes, they're saying everything we did was illegal, that submetering was illegal, that we had base charges that were illegal, and that we didn't separately submeter the common areas, that somehow we were charging them for the common areas. But none of that is correct, as I just pointed out.
Well, you can't submeter at all in certain contexts, correct? At least mine all can't.
What this is, Your Honor,
I'm not sure you want to spend your time arguing this point, but go ahead.
No, certainly the rules and regulations say a landlord cannot submeter. They don't want, it was back a case from 1950s, I believe. Landlords are not supposed to resell utilities. It's not proper, it's unfair to the tenants. No, we're not disputing that. I think what's happened here is that technology has outpaced the rules and regulations, because these submeters are only measuring the actual use in each unit. And there's a whole series of letters with the Department of Public Utilities in Volume 2, pages 114 through 128. And there was some confusion about what regulations apply, but there's also, there's a letter, I believe, from the Clinton, or the company with which we had the contract, that the Department of Public Utilities will not be pursuing a correction to gas submetering, because I'm supposing here, they realized it was separately metering it, but the rules say you can't do it. So here we have this conundrum that we're faced in.
Let me ask you another question. You heard the hypothetical I ran by your brother about whether or not an expert could have looked at the utility usage at one of his client's apartments and determined whether or not, let's say, National Grid or some other utility provider would have charged the same, lower, similar, or higher amount for the utility usage at that apartment. Do you agree with his conclusion that an expert could do so?
In theory, Your Honor, you could find an expert to opine to anything. They had multiple opportunities to do this. They never came up with one. There were two affidavits.
But you just said in theory, so, I mean, I could articulate the question in full again, but I think you get the gist.
I get it. Of course,
Do you think at a fundamental practical level, an expert could be retained to actually make that very determination, is my question.
I think, yes, they would need to do that in order to prove damages.
Do you think they can do that? An expert is capable of doing that? Or would you say not really, because of all of these different considerations, so it's not a possible task?
I think based on the record and the fact that they don't have one shows that perhaps they couldn't find somebody who could articulate damages as required by our current case law.
Well, is that a problem for you? In other words, are you setting up some sort of a straw man where you say, well, you need an expert to prove that, and yet an expert could not make that proof based upon, because utilities are subject to so many different variables?
It's their burden of proof. They didn't prove it. We come to court and say they're supposed to prove damages. They can't prove it. Here's why they can't prove it. We have affidavits where these individuals looked at this, said, this is how you explain the base charge. This is how you that no common area is being billed. And then there's another expert affidavit of Jeffrey Spratt, Volume 2, page 209, and page 212, paragraph 16, that the plaintiffs actually paid less in rent than they would have had they were charged for utilities. Some landlords will charge utilities as part of the base rent. That's a constant charge. In this instance, because in warmer months, for example, you're not using as much gas, for example, they're charged less. So he says that they were charged less Since they were only charged for actual use, they were charged less than they would have in other comparable apartment buildings. So again, over and over again, we see a failure to prove any damages, and the evidence in the record is to the contrary.
Neither of those affidavits appears to have been part of your summary judgment Rule 9A submission, if I'm reading the appendix correctly. They're both included in Volume 2, as you've just noted, and Volume 1 of the record appendix appears beginning at page 91 and continuing through the end to contain, oh, no, you know what, I apologize, it goes on into Volume 2. So it does look like they were part of it.
And finally, Your Honors, I'd like to address one other point, and that is the arguments that counsel's making might have been appropriate if I was the landlord, but Minol is not the landlord. Minol is a third-party billing provider, and the rules and regulations apply to an owner or a landlord, of which we are neither. So they're saying they don't really have to prove damages. Oh, but then they say, well, they've got these improper base charges, and that therefore that's a thing. They still rely on the Freeman case from 1997, the Liardi case, from 1985, both of which were the holdings of those that say you get nominal damages were overruled, in essence, by Tyler, which says you've got to prove damages. So because they haven't proved damages, we ask that this court affirm the summary judgment ruling in our favor.
Do you agree that damages in that context can be economic or non-economic to show injury under Chapter 93A, Section 9?
They certainly have to be economic. As to non-economic, I'm not sure that's met here. And I'd have to go back and reread the case law, because
My question is, can it be either? My understanding is it is, because Chapter 93A used to state you must show loss of money or property. That was amended in Section 9 to, instead of proving loss of money or property, they're only required to prove injury. So, and I believe what our case law has said is that that recognizes non-economic injury as well, but it doesn't eliminate loss causation.
Violation must cause some, I'm just reading from Tyler, it must cause some separate identifiable harm.
Which can be non-economic, correct? If not, then what was the purpose of amending the statute?
Perhaps in some instances, Your Honor, it could be non-economic, but I don't think they've proved that here or shown that here.
No. Thank you both. This is a very complex case. It was well briefed and well argued by both parties. Your clients received excellent representation. Thank you both. Case is submitted. Calling docket 22P418, PA versus AA. Good morning, counsel.
Good morning. May it please the court.
Before you begin, I'd ask you to keep in mind that this case is impounded, at least partially impounded, so please do not reference any proper names and refrain from referencing any impounded material, okay?
Yes, Your Honor.
Thank you.
Della Proto for the appellant. Your Honor, we are here today because I'm asking the court to vacate the 209A order that was issued by the Lowell District Court.
Counsel,
Just going to speak up a little bit, please.
Sorry. I'm just asking the court to vacate the 209A order that was issued by the Lowell District Court. I think the issue in this case, Your Honor, comes down to, first of all, we have to look at the reason that the court, the section under which the court actually allowed or ordered and granted this 209A. It's a little unclear, but I think from the record and from what was stated at the testimony and from the judge's remarks at the end, he granted it under Section 1B, 209A 1B. As opposed to 1A or 1C, which for the purposes of this case does make a difference. So under 1B, the plaintiff was required to show imminent harm due to a physical abuse. And I think the issue here, despite the fact that there were 3 DCF reports that were found unsubstantiated, despite the fact that there were 2...
We don't have those DCF reports in the record.
That's correct.
So we can't speculate on why they're unsubstantiated.
That's good. They were just referenced in the transcript during cross-examination. The plaintiff's mother confirmed that they were unsubstantiated. Same thing with the police report. But that's not the path that I'm going to go on, because the trial court makes the credibility determinations to begin with, and I think it'd be very difficult based on the testimony provided, especially by the minor plaintiff, for the court to overturn that. But I think the issue here in this case is a second prong. I think when you have to show, under Section 1B, you have to show imminent fear of harm, but you also have to show it both objectively and subjectively. And I think the issue here is whether or not objectively the court could have found, based on the fact that the plaintiff was in imminent fear of threat, of any type of harm. And I want to point the court to the transcript and to my citations. The issue is that all the abuse and everything that was alleged, everything that was testified to, all the parties, I think, agree, including the plaintiff's mother, and the brother that testified, all of them agreed that it occurred at least 3 to 4 years prior to the hearing. In fact, I think the mother is very clear. I think it was page 10 of the transcript, where she said that the defendant had not spoken to the minor in about 3 years, and she confirmed that. So they have not spoken for 3 years. And I think that the fact that this case, there was such a long period of time during which there was absolutely no contact, without a 209A order in place, there was no contact, I think puts us into a realm of some cases that have already been decided when they talk about the passage of time. But before we even get to that, I think even when we look at the affidavit that was submitted by the plaintiff on behalf of the minor and the minor's testimony, the issue wasn't that she was in fear that he was going to come and harm her. The issue stemmed from him calling him, the father, calling the school and asking for access to records.
That affidavit, I'm sorry,
Go ahead.
that affidavit is redacted in part. Is that just the removal of proper names?
That's my understanding, Your Honor, yes.
So it was not you who redacted it, was already redacted?
I redacted it, and I only redacted the names when I submitted it for the purposes of redactions.
Okay. It's just hard for us to tell when these events occurred with all the redactions. At page 6 of the transcript, the minor plaintiff testified, he physically and sexually and verbally and mentally abused me for years. Why isn't that a sufficient basis for the judge to issue a 209A order under 1C?
Because that's not the ruling that he made. I would agree with the court that perhaps it would have been sufficient maybe under 1C based on the case law, but I don't think that that's what he decided on. We have to go by what he decided on. But I do want to address that
Do
point.
we have to go by what he decided on, or do we go by whether or not the evidence in the record is sufficient to warrant?
Well, I think it's also insufficient based on 1C, and the reason that it's insufficient based on 1C, and I think that there's case law that talks about that, it's not an automatic. Just because they allege that type of abuse, it's not automatic that the order will be granted. There still have to be separate findings made.
So when the judge said at page 33 of the transcript, I did hear the testimony of the minor, the mom and the brother, and all testified to repeated abuse and made some allegations of some other abuse, and I find the testimony to be credible. I find that because the testimony is credible and because it's more likely than not in my mind that some form of physical abuse or mental abuse occurred, I do find that the plaintiff would be in imminent fear of serious bodily harm. So are you saying that that finding by the judge, or that statement by a judge, amounts to his saying he didn't believe her when she said the defendant had sexually abused her for years?
No, I'm just saying that that's not sufficient to automatically grant the order. He had to have made additional findings in addition to just that the abuse occurred. It's not sufficient. I believe that case is, I do have it here. I didn't cite to it because that's not, I proceeded under the 1B section, but I think it's Yana versus Sylvester S. 97 Mass Appeals Court 184 of 2020. That case talks about the fact that it's not an automatic granting just because they're alleging abuse under 1C. There have to be additional
But it also
findings.
says, because the plaintiff seeks protection from the effects of past sexual abuse, she need not allege a fear of imminent future sexual abuse.
Exactly.
So the minor was not cross-examined at all. all we have is her statement is he sexually abused me for years. And you're saying that that's not enough to issue a 209A under 1C.
Yes, Your Honor, and I think the other issue is that, again, the judge himself, the trial court, did not make the finding. He said some other abuse, physical abuse and mental abuse. He did not make the specific finding of sexual abuse as the minor testified. In addition to that, I think the extent of the sexual abuse as described was the spooning, which is grabbing the person from behind, which was what was alleged in this case based on the testimony of the minor herself, I believe, and the mother and the brother. And again, just going back to 1C, it's the fact that there's nothing else here to trigger anything is, I think, the issue. There's nothing in the other case under 1C, Your Honor. Again, the issue is that there has to be some sort of trigger or something like that. And what I'm saying is that this case is sufficiently different from where courts have decided under 1C because there's been a long break, because there has been no physical or no visual, no physical or no communications. My client did not reach out to the complaining witness. My client did not see the complaining witness. My client did not go to the school. He made a simple phone call, which, as the father of a minor, based on what is in the record, I believe he had every right to make about his own child. He didn't do anything wrong. He didn't do anything like that. The only reason that the minor child found out was because the mother told her. He didn't do any acts towards the minor.
Did Sylvester S. do anything wrong by walking into the dining hall at UMass Amherst?
He did not, but I think it's a different type of a triggering. It's one thing when you see somebody, and it's one thing when you hear somebody said something, asked about something about you. The minor herself testified that she was just afraid that the father was going to show up and that he was going to show up to the school and that he was going to inquire about her. My review, and I apologize if I missed it, but my review of the transcript did not indicate that she said in her testimony, I'm afraid he's going to come and hit me. He's going to come or do something else to me. The issue was that she was afraid that he was going to go to her school. And I think that that's the issue. That's what distinguishes this from Sylvester S., that there was no actual, like, seeing somebody. There was nothing sufficient to trigger, especially in a situation where, the 3 years have passed since they had any type of conversation whatsoever. And I think in Sylvester S., Your Honor, again, it was a much more, it seems like from the facts that there was much more physical, much more sexual abuse than the simple spooning that was testified to in the record by the complaining witness or by the minor defendant.
It was the brother who testified to the spooning, though.
I'm sorry.
Wasn't it the brother who testified to the spooning?
I believe it may have been both, Your Honor, but definitely the brother. The brother for sure testified that he would watch them come from behind. That's what he classified as spooning. But I think that just focusing on the 1C, again, under 1B, I think that it would not be appropriate to grant it because there's the Dolan case, which had the same had a 4-year passage of time, and the appeals court stated that's not, you can't have harm after 4 years, it's the time period. But just going back to bringing this to 1C or to 1A, I think the distinction between this case and the cases where the courts have allowed that 209A order was that there was a trigger that was much more severe than here, was a trigger that it was something that would have triggered the plaintiff.
This is a yes or no question. Was the restraining order renewed on December 23rd of 2022?
I can answer, but no, it was not.
Was there a hearing, or was it simply a no-show?
So I did not represent the defendant in the initial matter or in the other matter.
We're outside the record now, so let's leave it at that. My only other question is, was there no contact between is the record clear that there was no contact whatsoever between your client and the daughter for the past 3 years prior to the school incident, I'll call it? Or is it simply that there was no direct or in-person contact for that 3-year period?
I believe, and I can turn to the transcript, I believe this is page 10 of the transcript. I think the mother was being cross-examined. I'm sorry, let me just go back there. If I can just have 1 second, just get to page 10.
I actually don't even need a reference. My question is pretty simple. Is the record clear that there was, prior to the school incident, there were 3 years of no contact whatsoever with the daughter, or just 3 years of no in-person or direct contact with
My
her?
understanding is no contact. Your husband has not spoken to the minor in 3 years. Isn't that also correct? The answer was yes.
Is it also clear that they hadn't seen one another at all?
I don't think there's anything that I found that's as clear as that, though there is a reference there that the minor child was in the hospital, and that my client did not
Right,
go.
right.
Did not try to go because he was told not to go by the mother.
And there's reference in the mother's testimony to a divorce. We don't have in the record before us what orders any probate and family court judge may have made with respect to visitation or custody or your client's access to school records. We don't have any information about any orders like that.
We do not. The only information that I believe we have for sure is that at the time during this 3-year period, there was no restraining order outstanding at the time.
Anything further? Patricia, anything further?
I think this is clear from the transcript, but can you confirm that the cross-country meet was before that 3-year window?
That is my understanding from the transcript, yes.
Okay.
Okay. Thank you very much. We understand your argument. Very helpful briefing, and the case is submitted.
Thank you. Thank you. Have a nice day.
Our final case on the list, docket 22P254, DCF versus Child 1 and 2. So this case is also impounded, so please refrain from referencing any of the parties' names or any other impounded material. Why don't we reference the older child to the extent it's necessary as Child 1 and the younger child as Child 2. Okay. Attorney Katz, you up from New York?
Yes, Your Honor.
Nice to see you.
Nice to see you, too. May it please the Court, Daniel Katz for the appellant mother. So it's undisputed that my client has struggled mightily with a substance use prior to the petition being filed, during the pendency of the petition, and she even admitted that she had used about a week before the trial. But that's not the critical question here. Just like if someone is poor, if someone has mental health issues, the question is, as we know, there has to be a nexus between whatever deficiency a parent has and the inability to provide minimally acceptable care. Not winning any awards for Parent of the Year or anything like that, but providing basic care. And here, we have evidence in the record from the nurse practitioner at the pediatrician's office that up until April 2020, when the children were removed, that office had no concerns. Child 2 was up to date medically and had been given her vaccines. Child 1 is reported to have been developing normally. There was a note about some behavioral issues, but in terms of mothers providing food, I mean, a child can't be nurtured and grow normally without sufficient nutrition, and clearly the evidence here shows that that was happening despite her struggles with substance use. She was living in the same home. It's not a home that will be featured in Architectural Digest, but there was stability in being in the same place for 10 years, providing shelter, providing food, basic necessities to bring up children.
Let me ask you a procedural question. Mother's testimony at page 37, she testified, she was asked if she was there to get custody of her children, and her answer was maybe not to get custody back. But I'm not ready to just give up all rights. And then in closing, counsel for mother, and this is transcript pages 137 to 139, did not argue fitness or unfitness. It seemed to be, did not argue fitness or unfitness. It seemed to be conceded, and counsel simply argued that mom's position was adoption was not in child two's best interest, and child two should be placed with maternal grandmother or kept in DCF custody. And counsel for mother points that out in their brief. They make the argument that that issue was waived or conceded at trial, the issue of unfitness. What's your response to that?
Absolutely not waived, absolutely not conceded. Mother did not say she was giving up all rights, and
But couldn't that be read as, I'm not fighting unfitness at this time, but I am fighting termination?
It could be read that way, and therefore, as we know, an unfitness determination does not mandate a termination decree. So we will still be talking about fitness as it relates to whether it is in the best interest of the child to terminate. So we are clearly not waiving the fitness argument, certainly in the context of termination, right? The judge has two steps, right? Is the parent unfit? Most of the time, we know when the parent is deemed unfit, it leads to termination. However, there are certain situations where the court says, well, even if the parent is unfit, this is not a situation like, there's a footnote in Vita and Melba mentions it. It's not, it doesn't necessarily lead to a termination. Most of the time it does, but not always. So given mother's statement, she's not giving up everything. So even if your honors take their argument that she's waived the fitness.
We haven't taken any argument.
No, I'm saying if.
Just to be clear.
I would implore you that it would be incorrect to say that she was giving up all, and therefore you could look at the fitness determination in the context of a termination decree. Just like, in a care and protection case, right? If someone is deemed unfit, they still have the chance to come back every 6 months for a review and redetermination. So, given that, let's look at the evidence that the other side says made her unfit because of her substance use. So first, let's look at child one, who of course is no longer part of this appeal, but they both bring up in their briefs and perhaps in their argument the fact that there were educational issues. Now, I implore your honors to remember the governor of this state declared a state of emergency. We were in a COVID pandemic. 1 million people died, over 1 million people died in this country. I challenge your honors to Google children having educational issues online, and I will bet you, I know I'm not supposed to bet the judges, but I will bet you that the people involved, the children involved having difficulties, were not specifically children involved in proceedings with state governmental agencies. This was not a problem specific to this mother, to this family.
But then, as I understand the judge's findings, the nexus between the mother's substance use disorder and her unfitness with respect to the younger child didn't have to do so much with schooling. It had to do with things like the child at the age of 5 serving herself breakfast consisting of ketchup.
Your Honor, take a moment, please, and think about that. How many children, when they are young, might go downstairs and make their breakfast? We have one piece of evidence that there was ketchup on the plate. Now, the SJC has told us that termination of parental rights is an extreme step. It is protected. My gosh, if you're going to terminate parental rights because there's one piece of evidence that on one visit a social worker saw ketchup on a child's plate, let's remember There was no evidence of any stoves being on. There was no evidence of mother doing drugs in front of the children. There was no evidence of a sexual offender. There was a stranger in the basement, but no evidence of a stranger in the house. There was no evidence
There
of
was evidence from child one's testimony, I believe, that mother goes downstairs to a room to do her thing while child two runs wild. Ostensibly, the inference was that mother was taking that time for drug use, I believe, and that child two was unsupervised and doing things that could be harmful to child two.
But that's too general, Your Honor, honestly.
That's just one example from the record. I mean, we could go through. Your point about the ketchup is understandable and well taken, but there is a lot more evidence there, which includes the lack of visitation or the inconsistent visitation, which you want to address at some point.
Even given inconsistent visitation, if you look at the testimony from the social worker, McGowan, and the judge's conclusion of being a strong, loving bond, I mean, yes, her visitation was not, it was far from perfect. But the evidence, the quality, as opposed to the quantity, she engaged, both child and mother engaged with each other. The department, let's face it, during COVID, there were, first off, virtual visits were not initially even offered. And the social worker even admitted that, yes, given the difficulty of being part of a virtual visit and kind of viewing and monitoring a virtual visit, there was engagement between the parties. And despite that, despite the fact that when visits became in person, they were in a parking lot during this COVID. Despite all that, despite her substance use, there was still a strong bond. There was no evidence of firearms left in the house. There was no evidence, like in adoption of Jacob, as mother driving to the courthouse knowing that she was under the influence. We don't have anything like that. We have a plate of ketchup. We have mother maybe going to a room, but they just don't add up in terms of allowing you to take this extreme, allowing the judge to take the extreme step of terminating parental rights, given the fact that there was this close bond.
On the catch-up front, I can't find this in the record, and I may be making it up, but my memory is that the child on that occasion told the social worker that she always makes her own breakfast. And I've had 5-year-olds. I know that there are unreliable narrator issues that can arise, so I don't mean to take that, with any more weight than it deserves. But is my memory correct that was reported?
She did say something to that effect, but I implore your honors, don't make such a grave decision based on that one testimony that is not in and of itself harmful, given the fact that the nurse from their pediatrician's office said that they had no concerns. So even if she were pouring herself cereal and milk.
What about the root canals?
You cannot make a causal line between mother's substance use and that. First, let's take the younger child. Oh, the root canals, that's the older child.
Didn't the younger child have one also?
She had a tooth pulled from decay. That was July of 21. The child was removed in April of 2020. You simply cannot make that determination, a causal connection that far away, even given the fact that the child, if you take his statement about in December 2020 that he hadn't been to the dentist in like a year and a half, maybe the mother was planning to go at the end of, after they were removed in 2020. So that would have, hopefully the dentist would have seen something then. So it's not so clear that you can draw this causal connection. And the SJC is constantly telling us, even recently in adoption of Luke, granted mainly in the context of a mental disorder. Because yes, there are these issues, substance use, but there has to be this direct connection. And there are cases out there, and I urge you, like I think it's adoption of Jacob I just mentioned in terms of the mother driving, but there are cases where there are, selling sex for drugs, doing right in front of the kid, coming to visits under the influence, having firearms, gas oven stoves left on. Okay, 1:22. Can I quickly go, or any? Okay.
Please, your time.
Just want to go, if Your Honors don't rule in my favor on that section, I would just like to add, in terms of, it seems grossly unfair that the judge only gave mother 2 virtual visits, given the evidence and the judge's conclusion that there was this close bond, and given the fact that it's so easy to have virtual visits. They don't cost anything. If something's going wrong, they can easily be stopped. And given the fact that there was such a bond between them, and again, I'll just make one last push, that there was simply no causal connection given her grave substance use issue, that the mother and the child, and maybe there's evidence now that this child has seen this great paternal aunt in California, but there's no bond established with anyone except for the mother and child too. Thank you.
Thank you very much. For counsel for the department.
Good morning, Assistant Attorney General Cassandra Bolaños for the department.
Thank you.
I'd like to address the nexus point raised by my brother. There was evidence that mother neglected child 2 and that her substance abuse caused her to provide minimally adequate care. First, in the words of the trial judge in conclusion of law number 7, mother's ongoing substance abuse endangered her daughter even before she was born. The child 2, was born exposed to not just methadone, but also to OxyContin and to marijuana, and she needed to stay in the hospital for an entire 3 weeks to receive neonatal morphine to assist with withdrawal systems. The judge also made a finding of fact that mother consistently used drugs while she was caring for the children. That's finding of fact 31. Mother said that she wasn't in a caretaking role when she was using cocaine and fentanyl, which is a very strong opioid narcotic with sedating impacts, but the judge did not credit that testimony in light of the fact that mother said that the kids were staying with the paternal grandmother when she used drugs, but the paternal
grandmother said she didn't stay here, right?
Exactly. The children were also living in an environment where they were exposed to drug use. The department became involved with the family, not just because of the positive drug screens as well as the missed methadone doses, but the father was visibly impaired on April 2nd when he went for his methadone dose, yet the mother permitted him to remain with the children in the home. The father again denied that he was impaired and said that the methadone made him drowsy, but the judge did not credit this testimony. There was also not age-appropriate supervision, including the child 2 saying that she makes her own breakfast every day, even though she had just turned 5. And that's discussed in finding of fact 41 and also exhibit page 39. Part of the breakfast that she did make for herself was ketchup on a plate, and the child did confirm that it was just ketchup. Again, this is one factor of many. It's a constellation of factors showing neglect. There was also, the department had concerns about drug use by other members of the household. They were concerned that there was drug paraphernalia in the child 1's room when an adult man was staying in that room while child 1 was staying in the basement. And even though child 1 has aged out, the court was required to consider any neglect as to child 1 in determining whether or not there was unfitness as to child 2. And that's actually a statutory mandate in Section 3 of Chapter 210. And here there was significant evidence of neglect of child 1, including the educational neglect, which
respectively, wasn't just because of the pandemic, because the evidence was that mother unenrolled him from his online school in January of 2020, and then 2 months elapsed and he was not enrolled in school and playing video games in the basement. The judge did not abuse his discretion in inferring that some of the dental issues that the judge faced were as a result of mother's neglect of his dental care. In January of 2020, he had 1 root canal, and the dentist said that he would require another 5 to 6 root canals due to the severity of the tooth decay. And by the child one's own admission, he said that he had not seen a dentist in at least a year and a half, which includes at least 1 missed dental appointment while he was in mother's custody. And perhaps the clearest example of the nexus is after the children were removed. There was a very clear pattern that when mother was actively using drugs, she was highly inconsistent in her visits. It's undisputed that mother was using drugs from April 2020 consistently through October of 2020. And in that time frame, she attended only 5 of 18 opportunities to visit with the children that the department offered her. And here, the judge found she did not attain any real period of sobriety. I believe there were 2 of 3 clean screens in November of 2020, 2 of 3 clean screens in February of 2021, and 2 clean screens in January of 2020. And
5 of 18 visits you just referenced earlier, that was in the first 18 months after the department took the child?
in the first, I'd say, 5 months.
First 5 months.
From late June 2020 through October of 2020.
Then visitation improved, and then it went down again.
And then it went down again. Mother resumed using drugs on February 25th of 2021, and then starting in March 2021, she again became inconsistent in attending visits, confirming visits, and the judge found most concerning that in the 2 months preceding the trial, July and August of 2021, mother did not see the children at all, except for 1 visit on July 6th.
Do you agree with Attorney Katz that the issue of unfitness is neither waived nor conceded?
I disagree. I agree with Child One's counsel that the issue is waived based on her attorney arguing only objecting as to termination and actually asking the court to place the children with other people, as well as the testimony on page 38 that Your Honor noted, where the mother said even as of the time of trial, she was not ready to have the kids returned to her custody. She was not fit to be their caretaker in her own judgment.
Well, to parrot Attorney Katz's argument, though, I think the greater point is unfitness is still a foundational requirement for a determination to terminate parental rights. So is the issue at least alive, and so at least under the rubric of termination?
It is. It is a necessary prerequisite to termination, and for that reason, the trial court had 158 detailed findings of fact addressing why it found her unfit and why that unfitness was unlikely to resolve itself in the future, such that it was in the child's best interests for mother's rights to be terminated. Even though the substance abuse posed a problem, mother failed to cooperate with the department. In the first 5 months, there was only 1 home visit. Mother failed to seek the consistent substance abuse treatment despite the department's urging her to do so as early as April of 2020. She never sought residential treatment, even though that was in her action plans, and the department asked her to do so, including during periods of active substance abuse. She waited 7 months before engaging in an intensive outpatient program. And while she did attain some sobriety while she was engaged in that program, she quickly relapsed, and the juvenile court appropriately found that she didn't benefit from the program because her drug use went unabated for the 6 months preceding the termination trial. Unless this court has further questions.
Seeing none, thank you very much.
Thank you.
And we will hear now from Attorney Campbell on behalf of Child 2.
Excuse me. Good morning. May it please the court. My name is Alan Campbell. It's my privilege to represent Child 2 in this matter. And also present with me in the courtroom is Mrs. M., the pre-adoptive mother, and the paternal grandmother, paternal great aunt to the child.
This is outside of this is just a yes or no question. Is the child in California or is the child in presently in DCF custody, or?
He can't answer that, yes or no.
Unfortunately, I can't
that's
answer that yes or
actually-
no. I can say, and disregard it if you don't like it, child is living with the pre-adoptive parent, but not in California.
Thank you.
And the child two asks that this court affirm the judgment below in its entirety so that she may be adopted by paternal great aunt with whom she's residing. This case is not about a plate of ketchup or a missed dental appointment or a few missed dental appointments. Contrary to what my brother just mentioned, counsel in fact did argue fitness in his closing, albeit implicitly. Mother's counsel asked that the court give custody either to the paternal grandmother or permanent custody to DCF. In order to do that, the court has to find mother unfit. Where trial counsel or mother's counsel asked the court to find the child unfit, mother's counsel cannot on appeal argue the court erred in finding the child unfit. That issue is waived, and it's directly against what the child or what mother asked the court to do. But even without that concession, the evidence of unfitness is great. Mother may have, at some point early in child two's life, been able to provide some minimally acceptable care. However, in April of 2020, mother and father's drug use reached a crisis, and she stopped being able to care for her child. The child was removed, and I'm just going to refer to my client. Obviously, at this point, it was children. The child was removed. Mother was given a service plan. Mother did nothing on the service plan other than generally sign releases and pretty regularly meet with DCF. Mother was not compliant with habit OPTCO. She did not participate in counseling. She did not participate in group therapy. She did not provide regular urine screens, and she did not do daily methadone. Mother did not remain sober. Mother did not enter residential treatment. Mother did not benefit from the virtual IOP that she participated in. And we know that because she relapsed within a couple months of completing the program and remained using up until at least a week before trial, or as recently as a week before trial. And mother did.
Campbell, I hear you on all of that, and obviously it does not show a parent putting a best foot forward to try to regain custody of a child. At the same time, though, all of the things you've mentioned specifically date from a time after the child was removed from the home. Looking at the time period during which the mother was actually the custodial parent of the child, what evidence do you think best supports the conclusion that the mother was unfit to be a parent to the child?
I believe the findings that mother was using heroin and fentanyl while in a caretaking role. Mother is essentially incapacitating herself while she is the responsible party for, at that time, a 5-year-old child. We do not have to wait for tragedy to strike before this court acts. And much of mother's argument here before this court is essentially, what about? She points to people that are worse. Yes, there are many parents that are worse parents. There are also parents that kill their children. That doesn't mean because a parent doesn't kill their children, they're a fit parent. You have to look at the parent. The parent, as the court says, mother was unable to commit herself to 4 hours of parenting a month. Mother is unemployed. She wasn't doing any of her services. And for the 2.5 months prior to trial, she couldn't even bring herself to visit the child. To then say, oh, okay, well, we'll give you back. Maybe you'll do a good job because you say, if you don't terminate my rights, she'll do what she needs to do. Mother has been trying to get herself sober for, I believe it was 15 years at the time of trial. And a couple of you have asked a question about, isn't unfitness alive in the context of termination? Well, yes, it is, because it's a two-step process. Is mother unfit? Yes, she said. Her counsel asked that she be found unfit. And 2, is that unfitness going to continue for the foreseeable future such that it's in the child's best interest that her parental rights be terminated? She's tried for 15 years to become sober. She's failed. Why would anyone think that that's suddenly going to change? It's not like she had a track record where things were improving. She had a couple, well, I shouldn't even say a couple, She had one brief period where she did something great. She did the IOP and she was sober briefly. She immediately then crashed, and the trajectory at the time of trial was actually down. We had a 5-year-old child who deserves stability and safety. A mother can provide neither of those. Her current placement can. And I apologize if this is off the record, but when I met with my client yesterday, she asked me to beg the court, her words.
I'm going to ask you to not
Okay.
go off the record. Attorney Katz, number one, don't speak when other counsel speak. Number two, I just said do not go off the record, and nothing off the record came in before this court, so there's nothing to say. Okay, thank you. Proceed.
So again, child would ask that this court affirm the judgment so that she can have the stability and the safety that a now 6-year-old child deserves. I think I may just quickly look at my notes to see. One other point about the educational neglect of the older child. Mother had failed to re-enroll this child at least 3 months prior to COVID. So the COVID crisis was not the cause of the emotional neglect. The child was not enrolled in school when the COVID crisis hit. The COVID crisis extended that neglect, but it wasn't the cause of the neglect.
Do you have anything to say about the number of virtual visits a year between the child and the mother?
Yes, there's no abuse of discretion in awarding 2 virtual visits. Frankly, if there had been no visits awarded, I would be arguing that that wasn't an abuse of discretion. But 2 is certainly enough. The pre-adoptive mother, or whoever ends up with it, although it does look like it'll be the pre-adoptive mother, can always give more. But 2 is certainly enough to maintain any relationship. Well, and as the judge said in his findings, he's balancing the rights of the pre-adoptive parent to be a parent and go forward as a new family with the child's rights, and found that 2 was a reasonable number, and that's certainly not outside the range of reasonable options.
And seeing your time has expired, we thank you very much. The panel would like to acknowledge the very helpful briefing and advocacy of all 3 attorneys. This is a difficult case. We will take it under advisement.
Thank you all.
The case is submitted, and that concludes our session.
Court,